Good evening, everybody. My name's Brian Burke. I'm an attorney with Sam Shehab and Associates, and it's Monday. It's 6 p.m., and that means it's time for our weekly discussion of some fun immigration topics and questions. We have a good one for you. We're going to talk about labor certification, that process. It's a very popular topic of conversation in our office because so many people want to get into the EB2 category right now due to the quick moving of priority dates. But there's also a new visa bulletin out very early, so we're going to talk about that. You might notice that conspicuously absent is my dear friend Sam Shehab. He is traveling at the moment, but have no fear. We've recorded a nice presentation on the subject of PERM, and I'm going to come back after that, and we're going to hit you on the subject of the current events, again, the visa bulletin, and all your fun, interesting questions. So stick around and enjoy.
Good Monday evening, everybody. I am Sam Shehab.
I'm Brian Burke.
And we are from the law firm of Sam Shehab and Associates. Every Monday, we meet here to discuss an employment-based immigration topic, to share it with our clients, our listeners, our friends, and have an attorney discussion of it. It's informal. It's designed to help create information out in the World Wide Web about immigration law.
Turn the gears in your head, yeah.
And today, we're talking about understanding the labor certification timeline and mechanics. A little bit different than what we've done before. We had a presentation about labor certification from a law perspective. Now we're going to talk about the law, but from a timeline and mechanics standpoint, when we return. So for those that don't have a whole lot of understanding what a labor certification is, it's an application with the U.S. Department of Labor filed by an employer, by a company, not by a foreign national, by a company or an employer, in which the employer tells the Labor Department is, I'm unable to fill certain jobs in my company because I'm not able to find the right candidates in the U.S., and I would like to rely on the international labor market to bring in qualified applicants. And they have to go through a labor certification process to certify, that's the word certification, to certify that there are no qualified U.S. workers ready, willing, and able to fill the job vacancy for that employer time of the application.
Yeah, and it is a requirement for immigration. It's a classic inadmissibility issue. It's basically you have to have labor certification if you're intending to come to the United States to work. Great, on a permanent basis. Now, I can't help but talk about history just a little bit, Sam. The present labor certification process is called PERM. It's PERM. That's the acronym for it. There's been a couple versions of it prior. And the magic of labor certification, these processes, is they've historically revised the processes to make them faster. And we've been on PERM since about 2004. And I can't say that PERM is fast anymore, Sam. I can't say that it's fast.
It can certainly get faster and more efficient, Brian. But I will tell you that it has gotten a lot better from the years where it took 2 years, 3 years to get a labor certification out. Obviously, the timeline that we have right now, which has crossed the 1 year to get one of these, is unacceptable.
Yes.
There's no question about it. But it has improved and more improvement needed. And one of the things that should happen is to charge a fee for this process. Right now, they don't charge a fee, which is for me, is mind-boggling.
Yeah, the government, uses those fees to hire people to do work, and well, the Department of Labor has none. It's really a great reason why they're falling behind.
Mechanics.
Yeah.
So what's the first thing? It begins with an employer saying, I have needs. I'm not able to fulfill my need as an engineering company, as an information technology company, and I'm advertising, I'm looking for people, I have consistent deficiency, and they go and say, I'm going to file a labor certification to show that I am not able to find them. There's a shortage in that.
Well, sure. It's what you do is define what that job is. Step one of the labor certification process, Sam, is to file a prevailing wage request from the Department of Labor. And that request...
Step number one is to define the job description.
I kind of roll them together, but yes.
Yeah, but that is, you as a lawyer that does a lot of it, you're kind of skipping.
Yeah, okay.
A little bit, for me at least. I think you have to define what it is that person does, what is the qualification needed for the job, right?
Sure.
And the title of that, but just for example, a mechanical engineer,
Yeah.
mechanical power engineer, design power plants, whatever.
Yeah. What's your title? What do you do on a day-to-day basis? And then, are there any special requirements? Licensure, do you have to be a civil engineer? What kind of degree is required? Do you travel around? Do you supervise people? All of these things that make up a job, which...
Potential licensing requirements.
Yeah. Yeah, so all this stuff that goes into a job, probably more thought out than your average HR job posting online. You come up with a very, tight list of what your requirements are. And then comes that prevailing wage request of the Department of Labor.
So you take that information and you put it on a form.
Yes, Department of Labor has a form where they'll ask you about all these aspects of the job, title, description, educational requirements, specialized skills, licensure, training, and you travel, yes, and you cram this all in a form in a nice, neat way, of course, and you send it to the Department of Labor in what's called a prevailing wage determination request.
And that's an electronic filing?
Yes, sir. Electronic filing with the Department of Labor, done online through a Department of Labor portal.
Okay.
And this is where I start talking about timeframes, Sam. You submit that right now. You're looking at over 6 months to get that prevailing wage determined by the Department of Labor. And the substance of that request, of that determination, Sam, is basically a job code, a broad classification into which that job is, and a salary, essentially.
So, yeah, I was going to ask you, the purpose of the form is for the Department of Labor to tell us how much the employer should be paying if they would like to hire a foreign worker, and the purpose of that is to protect the U.S. worker.
Yeah.
Because you don't want a company to say, you know what, I'm going to hire a foreign engineer because they're cheaper. Yeah. What that process is protects against that. Yeah. And how long does it take, in your opinion, for a Department of Labor worker to complete and enter this missing information from a work hour standpoint?
20 minutes. Yeah. They're going to have to make a thoughtful review of the job, and then,
and they're going to look up a database that we know.
Yeah.
We have access to that database.
Yeah, we have access to that database. And, I know for me, for having experience with filing prevailing wages, I can get a good idea of what a prevailing wage is going to be based upon knowing their systems, in a snap. And it takes them...
It's a mechanical engineer position. Yeah. And then you have to look up the location, the locale.
It is very dependent upon where you're located. As a mechanical engineer in Columbus, Ohio might be different from Michigan, where there's tons of auto manufacturers, for example.
And then there are 4 levels.
Yep.
And level 1 is entry level, level 4 is lead, and 2 and 3 are in between. Yep. And based on the job description, the requirements, you can make a very good. I mean, it's not
educated guess.
It's not like you don't even need to make an educated guess. You make an educated set. It's not a guess. There's no guessing in it. If the person is leading, then it's a level 4. If the person is entry level, without prior experience, he's level 1. Yeah.
So great big disconnect then, Sam. About 6 months for them to actually do it versus what we suspect it's about 20 minutes or less of actual.
So it should be really a 24. I mean, this could be 1 week process.
Yeah.
I mean, 1 week, and that's giving them a lot of time. Yeah. Because I mean, a Department of Labor worker can do 2 or 3 of those an hour.
Yeah. Easy. Yeah.
So you get it 6 to 7 months later. They tell you what the salary is. What's the purpose of knowing the salary?
Well, so you can move on to the next step.
What is the next step?
The next step is recruitment.
The next step is recruitment for the labor certification.
Yeah. So the whole point of this process is to see whether there are any U.S. workers ready, willing, qualified, able to accept this permanent position. If there's U.S. workers out there who are in this role, Department of Labor says, hey, no, you can't proceed on this case. That's the process works. But so you have to test the U.S. job market by doing recruitment to see if there are actually any U.S. workers out there who want the role.
Okay. So let's talk about the timeline. What are these recruitments for? Let's break it down for us.
So, it varies a little bit between the type of labor certification you're doing, but there are some basic requirements across, all labor certification cases. 1, Sunday newspaper ads. 2, Sunday newspaper ads. That's, in your local big metropolitan area newspaper. If you pick up the Sunday paper, you're probably going to see some labor certification positions in there. A job order with the State Department of Labor. Every State Department of Labor is going to have a website where an employer can post jobs. You will find, you'll find non-labor certification jobs there as well, but it's just a job board. It's run by the State Department of Labor. Gets posted there.
Well, I think the majority of them are not labor certification. I mean, I'm thinking a labor certification is just.
Oh yes, so State Department of Labor do also beyond this, for sure.
And on the face of it, whether it's a newspaper ad or it's a state department, a local state department job order, or whether it's an internet advertisement, one of the requirements is that the potential applicant cannot discern whether this is a regular or for a labor certification.
Exactly, that's such an important point.
Because you need an honest search or test of the labor market.
Yeah, because hypothetically, if somebody said this is a perm job on here, somebody would have to just go, oh, what's perm? Oh, that means this is just a test of the U.S. job market. That could be considered to dissuade U.S. workers. So no matter what, you're right. No matter what recruitment you do, the utmost care has to be taken to give the hypothetical U.S. worker out there a fair shake, to give them the benefit of the doubt on everything.
And it has to be conducted in what we call good faith.
Yeah.
Meaning that you really are pursuing finding out whether or not there's qualified U.S. workers out there, and it has to follow these guidelines that are published by the Department of Labor regulations. But on top of that, it has to be consistent with the company's method of hiring in general.
Yeah. So you have to meet those DOL requirements to make sure you're complying with the labor certification rules. Mm-hmm. But you should be, doing recruitment like you would for anybody else, and just making sure those things overlap.
Yes. Can you give us examples of these advertisement or recruitment methods?
Sure. They give you a sort of menu of options, and for most cases, what we call for professionals, being IT folks, engineers, similar professional fields, you're required to do some additional recruitments, and you can choose from a menu. There's things like job fairs, a local job fair, and websites, your company website, mm-hmm. job search websites, Indeed, Monster, or whatever your favorite one is. Mm-hmm. Employee referral programs. That's when you have your employer says, hey, if you know anybody who wants to join our company, send us their resume, they can join us. Mm-hmm. Campus recruiting, such that you send a representative to a college campus to see if there's any any graduates. Radio and TV ads, private headhunter firms. Those are the sort of things which you can use to do to meet these recruitment requirements.
Which is the traditional recruitment requirement. I mean, and nowadays some of these things. Clearly campus recruitment is very popular.
Yeah.
But these are more for entry level, not for people with many years of experience. Although you can pick up some really good people in the advanced degree area with background. Yeah. But like Sunday ads, this is a leftover from a
bygone era,
Stone Age method of looking for people. But maybe certain jobs, they still do newspaper ad. But when was the last time you picked up the Sunday ad looking for a job?
Well, yeah, that's true. So those are, exactly. But Sunday ads are required, so everybody has to do them as part of the perm process. But I think practically speaking, that's why there's a nice menu of things. There is some versatility built into the perm system. There's I think it's 10 or 12 different options of these additional recruitments you can do. Mm-hmm. Meaning, practically speaking, anymore, I think most employers are going to be focusing on the most modern ones of those. It's going to be, websites, employee referral programs, that sort of thing. Yeah. The things which where the average person is going to be looking for a job.
So when you do these recruitments, obviously, one of two things is going to happen: either you do or you don't find qualified U.S. workers. If you don't find qualified U.S. workers, it's pretty straightforward.
Your case,
You move on.
Yeah.
Right?
Yeah.
You basically complete that labor certification application, and then you file it, because the labor certification application is an audit-based process, and an audit-based process is a process by which the Department of Labor requires you to conduct all these activities, and then you complete a form and you submit it, and then the Department of Labor will selectively review cases. They will not review every case.
I would emphasize that form, the final perm form that's submitted, is sort of a summary of everything you've done over the last 6 months or so. In this case, it's here's the prevailing wage we got, here's the recruitment that we did, here's information about this individual we're seeking to certify it for, and we sign off swearing that we didn't receive any qualified U.S. workers. And if the Department of Labor is satisfied with that when they review the case that gets submitted electronically, they will certify it. If they have questions, they will issue an audit, which is comparable to a USCIS RFE, saying we want to know more before we can make a final decision here.
Now, if we receive resumes from potential qualified U.S. workers, then we are required to potentially.
There's going to be some interviews that are going to happen. You can't just take the resumes and go and throw them in the garbage. That company that's seeking labor certification is going to have to contact those U.S. workers to make sure to evaluate them. So the recruitment process, if I wanted to state it very simply, can take generally speaking, the recruitment gets placed for about 30 days, and there's a 30-day waiting period built into the regulations for that. But beyond that, your employer absolutely has to make sure that they're properly vetting U.S. workers, and that's a process that can take time. You have to set up interviews. You have to play a little bit of phone tag with somebody. You may have to call them back later to clarify these things, and ultimately you have to good faith recruitment means you are giving every U.S. worker the benefit of the doubt. So that can take time, I guess is the point I'm making.
Yes. And if we find through this process that there is in fact a qualified U.S. worker, what happens?
That's the end of the labor certification process. You cannot file
So the application dies.
Yes.
And this person cannot move forward to get a green card because there is a qualified U.S. worker. The process that the Department of Labor asks us to use has turned out a potential U.S. worker.
Yeah, so these are the things I want to hit. We're talking about timeframes. The recruitment isn't guaranteed to be 60 days because it's very possible for it to extend beyond that. Vetting candidates in the proper way, and the case may never hit the filing date because if you're a qualified U.S. worker, you just have to stop. You can't sign off on that case in the end and properly file it if there's a qualified U.S. worker.
Can at a later time the employer pursue another application if later on they find that there is still have a need and the one or two qualified U.S. workers did not really either he wasn't able to hire them or they no longer are available?
Yeah, that's definitely can be revisited.
He can revisit these opportunities.
It's not the end of the process. I guess the point I would make is, there's no guaranteed time frame for labor certification. You don't know the process until you go through it.
Yeah. So let's assume we either did not find qualified U.S. workers, or we reviewed these applicants and the employer through a very careful review process was unable to find a U.S. worker who is qualified based on the job description. That's when you file the labor certification application, right?
Yeah.
And then what happens?
Well, electronic filing online through Department of Labor website. Unlike USCIS, they don't send anybody receipt notices in the mail. They'll best send the employer and their attorney an email. There's no way to track it in a public portal like USCIS, and they don't really give you any updates during the process. You'll get a labor certification when your employer and their counsel gets an email from the Department of Labor saying, congratulations, the case has been certified. How long, though, is the devilish question? 6 to 7 months right now.
July 2022, 6 to 7 months to process a labor certification and 6 to 7 months to obtain a prevailing wage.
Yeah.
And then a 60 days for the recruitment minimum and add a little bit of time to interview.
Yeah.
So to me, that sounds like a 14, 15 months process in July 2022.
Yeah.
What's the fastest timeline you've seen it, Brian? You've been doing this for a decade now.
Oh boy. Prevailing wages, about a month. And perms probably maybe 3 months, the actual filed case coming back from the Department of Labor.
So, and add a couple months for the recruitment.
Yeah.
So that's 5, 6, 7 months, maybe 7 months, 8 months.
Yeah.
And now we're up to 14 months approximately.
And I would mention that I sort of monitor whether these time frames are increasing or decreasing. I'm not seeing them
Getting better.
Yeah, I'm seeing them just slowly creep up. When we're at 6 months now, more to the 7 month mark.
Wow.
So.
Okay, sounds good. So anything else on labor certification that you would like to share?
Well, one thing we got to mention, Sam, is audits. Just because you filed the labor certification doesn't mean it's going to be approved by the Department of Labor.
Mm-hmm.
If in review of that labor certification form, the summary of everything that's done, they have a question, they can issue an audit. An audit is comparable to a USCIS RFV. It's, send us more information so we can make a decision on this. But in the form of an audit, the Department of Labor will usually want to see, okay, we want to actually see, that recruitment you did and all the background stuff you summarized.
How long that takes?
Adds a couple months to the process. They give you about a month to actually respond to the audit once it's issued, and then it's going to take them a couple more months in order to actually
Total time?
I'd say another 4 or 5 months to the process.
So it could be pushed in from 14 months to 18 months.
Yeah.
19 months.
Yeah, and
With an audit, and what's the percentage of audits?
Very low. I mean,
less about 5%.
I'd say less than that, honestly. However, sometimes I would swear they all get together at the Department of Labor, have a meeting, and then they start auditing on a specific issue, and then everybody has a whole lot of fun.
Yes.
But it depends upon where the sun is in alignment with the stars, and who's in the White House, and things like
Random.
that. You can never and you can never predict it because they are random as well.
Yes.
So
well, that's the labor certification.
Yeah.
Well, we'll be back to answer questions.
Well, hello everybody. I'm back. For those of you who missed the beginning, Sam is doing a little bit of traveling at the moment, but I'm here and we still have a little bit more to talk about in terms of current events. So we have a very early visa bulletin this month. It was issued late last week. Today's the 11th. That's the first week of the month. Pretty crazy to me. And we'll take a quick look at it here, and I'll just sort of give some thoughts. There we are. So there they are, the final action dates for August 2022. Basically, we have zero movement in EB2, and that's across the board, and a little bit of movement in EB3. And let's see, what else we got here? We have dates for filing in August 2022. Again, EB2 is stagnant, but EB3 has moved ahead a little bit. What that movement was, let's see here in my notes. It was EB3 nearly 2 months for China and 1 month for India. And in case anybody hasn't heard, USCIS, in terms of accepting adjustment of status filings, is using the final action dates, meaning they're not using the dates for filing. So, couple thoughts about these numbers. So, and I'll sort of put them back up on the screen so I can show what I'm talking about. So the dates for filing for EB2 India, they have gone back to 1st of January 2015, and for those of you who remember October 2020, that's the furthest date that they made it forward to. So essentially, what we've been talking about for a while now is that the visa bulletin seems unlikely to go beyond January 1st, 2015 in terms of dates for filing or final action date during this fiscal year, because that will generate new cases coming into USCIS. And based upon data we've seen in the past, we believe that they have enough capacity, enough cases in their hands already to use up all the visas available for this year. So that's probably why we're not going to see any movement beyond January 1st, 2015 during this fiscal year, which ends on September 30th. And on EB3, that's interesting too. There it is, final action dates as well as dates for filing have moved forward a little bit. And I will say that we weren't expecting much movement in EB3 at all. And we do have a theory about that though. I'm sure many of you guys out there have, not only have you jumped from EB3 to EB2 because you downgraded to EB3 in October 2020 and now your EB2 dates are current. Some of you folks are getting green cards in the EB2 category now. And the possible reason for that EB3 movement is that essentially EB3 categories clearing out. Over the last several months, USCIS and Department of State have moved their visa bulletin and encouraged, interfilings and second adjustment of statuses, depending upon, how they move those dates every month. And when people move to EB2, and we know so many people downgraded to EB3, they go into EB2, they get a green card, they're out of the EB3 queue, they're out of the EB2 queue, and the EB3 dates go forward. So it's pretty interesting stuff, and obviously we're coming to a point where we're going to be able to look forward to the October visa bulletin pretty darn soon. It's just a couple of months away, and I think that's going to be a very interesting one. That's going to take into account how many green cards USCIS actually issues this year and what sort of rollover that we get from the unused family preference green cards this year. It's going to be an exciting time. So right now, I think we've hit our midway point where I'm going to start taking some questions. I thank you for the ones I've gotten already. And stick around, and I will be back to take your questions. Well, once again, thanks everybody for sticking with me. We're going to take some questions right now. I've already been looking at them already. Let's see what we got. So from Kumar P, it's, can we expect the filing date for EB2 December 2015 to become current in fiscal year 2023? So I'm going to get this out already. I am looking forward to October Visa Bulletin, which will be the first Visa Bulletin of fiscal year 2023. If somebody's not aware, the USCIS fiscal year ends on 9/30 of a given year, and the new one begins on October 1st. So that October Visa Bulletin is really going to reflect all the new visas that are available in the next fiscal year. I've been sort of analyzing some numbers, looking at them, the number data from the Department of State, as well as what USCIS has been doing. And the subject of next week's presentation is going to be, what kind of rollover are we going to see in October 2020, and what kind of visa availability we might see in 2020. And I know those are popular topics, and we're going to hit it there. So save my complete analysis for the next Visa Bulletin, the next presentation next week. I think there's a pretty good chance we can get to December 2015. That only represents, a year of movement from where the final action dates are right now, and I think that's possible. Let's see what else we got here. So from Yogesh Krishnaswamy, so USCIS claims that they've issued 149,733 visas till May 2023 in their official website FAQ. If this were to be believed, will they utilize the remaining approximately 130,000 between June 1st to September 30th? So excellent question, Yogesh. And I think what's something very interesting here is that FAQ, as far as I can tell, was updated someday last week. And this is the same FAQ page that USCIS published a little while back. So they seem to be updating those FAQs on a rolling basis. So that number, of 149,733, there's a couple ways to look at it. Firstly, I'd say good job USCIS. You have exceeded the typical visas available for a year, which is 140,000. That means they've done more this year that there's normally available for a given year. However, the other side of the coin is there is 1/3 of the fiscal year left based upon that number, beyond from June, July, August, September, and approximately 1/2 the work left to do. And if you look at this thing very simply, I would say to myself, gee, I would hope that, halfway through the fiscal year, that they would be halfway through the green cards that they need to issue. And for those who aren't aware, it's 180,000. About 281,000, a pretty big number. And so great. That's a problem. 130,000, that's a lot of work. The other side of this coin, this is something we've been considering, is, has USCIS finally gotten the ball rolling? There's a lot of cases, 130,000 visas not used as of that, time in May USCIS mentioned. Maybe they've really pushed most of these cases so they're mostly at a point where they can start approving them very quickly en masse. They say, per that same FAQ you've been reading, Yogesh, that they are well positioned to use all those visas. I don't think anybody has the answer to that question. Are they going to use all those at this point? But it will be very interesting to see, and that's going to have roll-on effects, because the more visas they use this year, the more significant the additional availability that we get in October of 2022. Because if they waste a bunch of visas this year, the new visas available next year will be less impactful, because those new visas will have to go to the people who already have pending cases and that need visas still. So I know Yogesh has a part 2 here, and I will get it here. So if the above is true, and that's, USCIS issues those visas, will EB2 dates of filing reach April 15th, 2015 in the October 2022 visa bulletin, and whether green card will be received by at least May 2023. What's my thought process? So, the visa bulletin, I think it is, Yogesh, it's definitely possible to hit a data filing for April 2015 during the next fiscal year. October, I'm not so sure. USCIS created a massive problem for themselves in October 2020 when they took in, tens, if not hundreds of thousands of green cards during that time. And I can't help but think they might try to find some way to meter the availability of the adjustment of status applications they take in when it comes to the beginning of the next fiscal year in October 2022. So ultimately, Yogesh, when you get to file that case is dependent upon when they make your priority current. So your follow-up question of, will the green card be received by at least May 2023? I can't say I'm optimistic on that front. So in your scenario, Yogesh, you're talking about getting an employment-based green card from filing in, in about, let's see, October 2022 to May 2023. That's, 1, 2, 3, it's about 8 months. Talk to the people in here elsewhere in the chat who have been waiting on USCIS to approve their employment-based adjustment of status cases since October 2020. Those folks are almost at 24 months of processing time. I wouldn't be very optimistic to see a quick approval on an employment-based green card like that. And another factor about this is right now, I don't know how many that USCIS are going to get approved, green cards employment-based this year, but it seems pretty clear that they are in a sprint right now. And we looked at their data for the first quarter of this fiscal year, because that's the only data they have out right now in detail. And they moved slow at that time. So they basically, if you look at the last quarter of the last fiscal year, they had big productivity in their visa issuance, and then the first quarter, it was way down. I can't help but think that the beginning of this fiscal year, they're going to go and slow themselves down a little bit. I don't like it, but it seems to be how they work. So it's a great question. There's so many factors at play, but I'm optimistic about some pretty decent movement in October of 2022. But getting that green card by May of 2023, I'm not so sure about that, Yogesh. So here's a question from Rajini Gupta. So I'm working for an Indian subsidiary of a US company. I-797 has been issued by company. Can I change employer and will I-797 still be valid with a new employer sponsor? Stamping has not been done yet. And it looks like there's a part 2, so I will check that out here real quick. Number 2. So case was picked in the H-1B lottery. How long does it take the H-1B approval petition to be approved? So I think that that second part is critical, Regini. And I'm going to go back to the first part for everybody's benefit. So if there's, one thing I'll have to clarify is there are many types of I-797s issued by USCIS. Essentially, any time that USCIS issues a notice, or most of the time that USCIS issues a notice on a case, it's on Form I-797. There's receipt notices, there's approval notices, there's biometric notices, there are interview notices. These notices are issued on Form I-797. Now, Regini, it seems that you have received an I-797 receipt notice for an H-1B cap case filed by, the U.S. company that's affiliated with your Indian employer. To be clear, a receipt notice is not sufficient to confirm your counting under the H-1B cap. So until your H-1B cap case has been approved, that receipt notice is worth very little. The only way you're getting H-1B stamping, H-1B counting against the cap is if you have an H-1B approval notice. So let's see. And the follow-up, to Regina's question here is, seems to apply to say how long it's going to take. So that's why I presume that your H-1B cap case is not approved yet. So to answer your questions, your H-1B cap case, if it's not approved, it's not good for a new employer sponsor. Great. How long will it take your H-1B cap case to get approved? Months. If anybody's not aware, if you have your I-797 receipt notice, you can go to the USCIS website and check their posted processing times based upon the type of case you're filing and the receipt, the service center that it's with. So if you go by the first 3 numbers or just look on the receipt notice what service center your case is in, you will get an idea as to what the expected processing time is. Remember, H-1B cap cases, for now at least, allow for premium processing. So if your case needs to be approved faster, you might consider talking to your employer about premium processing. So even after your H-1B cap case is approved, it begs the question, once your cap case is approved, that's when we can start talking about, hey, is that valid for use with another employer? So when we read the rules very carefully, the rules seem to say that you're not considered counted against the H-1B cap until your H-1B, you've been issued an I-94 or you've gotten stamping. However, I don't think USCIS views it that way, and I think it's a distinct possibility that once you have a H-1B cap approval, and best case scenario is to wait past October 1st, is that USCIS might consider you cap counted if you file a case through a new employer. But your mileage may vary on that one. So big picture, it could take some time for an H-1B approval. Premium processing is available, but once that approval is in, you might consider changing employers with another H-1B filing through that company. So I'm going to keep on going here. Sneha Mehta, I'll send your regards to Sam. He's not here. So a green card holder can't stay outside of the USA for more than 6 months of the year without a reentry permit. Are they saying the same calendar year or any continuous 12-month period? So basically 6 months, any duration of 6 months. And Sneha, I want to, this is the sort of thing, let's take a pause right quick here. And I want to remind everybody, I'm here, I'm an immigration attorney. However, this is a YouTube live session and I don't have an attorney-client relationship with anybody out there to the best of my knowledge. And immigration questions are complex, and my best advice to anybody out here is if you have a serious concern about something, talk to an immigration attorney. We're nice people, we're nice to talk to, and your challenging questions, any of your questions thus far on here, guys, are something I could probably talk to you for, about a half hour with. So I think what I would tell you, Sneha, is that, your permanent residence can be questioned at any time by the U.S. government. Really, if at any time the U.S. government believes that you are no longer residing in the United States, they can start questioning, the validity of your green card. So I think it would be worth your time to basically really sit down and kind of, learn what the rules are. Because some people believe that, hey, I can just come back, every 3 months, step my toes in the water of the United States and continue living abroad. That's a scenario that gets people in trouble. I have talked to people about this. They'll call me up and they'll say, Brian, I was basically, I know I want to keep my green card. I've been coming back to the United States for a week every 4 or 5 months. And the customs folks told me I can't do that. And I'll say, yeah, you're right, because a permanent resident is somebody who resides in the United States. And if they don't believe you are residing in the United States, the place where is your home, the government can actually question whether your green card is still valid and make your life really quite complicated. So it's a good topic to think about. Going to keep it going here and see what kind of questions we have coming up. So from Rahul Jain. So my priority date is November 2014. AOS filed with medicals, 45J on 5/27. Biometrics applied on 6/7. I-140 approved, so my file is documentarily complete. Cases with NBC. Can I expect my green card by September 30th? So, great question. So, Raul, if you're not familiar, and if anybody in our audience isn't familiar, USCIS put out this FAQ a couple weeks ago saying, we believe we are well positioned to issue all green cards available, the 281,000 some available this year before the fiscal year is complete. They're essentially saying, we don't think we're going to waste any green cards. And for you, Raul, your priority date is current. Your case seems to be complete. I don't think it's crazy. I think it certainly wouldn't be crazy if you saw your green card approval by September 30th. But if you go back, a couple minutes to our earlier discussion, boy, they seem to have a lot of cases, 130,000 green cards to get through before the end of this fiscal year still. That seems to be, that's almost an entire year's worth of work in 4 months. I don't know whether they can do that, and I can't help but believe that there are some people who are going to have current priority dates and that may not get their green cards this year. I sincerely hope, I don't want anybody to be one of those. I'd say, be hopeful, but what I say as an immigration attorney, don't count on anything in the government until you have it in your hands. So from Sarabi Verma, with EB3 moving forward in the current visa bulletin, does it mean EB2 might pause and EB3 moves ahead? I don't believe so, and I will bring up the visa bulletin, Sarabi, to illustrate the point here in a minute. So why is, first the question I kind of answered earlier, why is EB3 moving ahead? Perhaps because, people are moving out of EB3 into EB2 where visas are available. But I don't really think there's much space for movement in EB3 right now due to the way the visa availability works. And I'm going to show you the final action dates for August 2022 here real quick. So if you look at the final action dates, everything's current, in the first category, right? And EB2, as we all know, has been racing forward in the last couple months. Because as USCIS explains, and we know as immigration attorneys, but USCIS has confirmed in their recent FAQs, basically the massive visa availability, the massive amount of extra visas rolling over from the family-based categories have to first be used by the EB2 categories that are backlogged first. So during this fiscal year, in order for all those extra visas must be used by the EB2 category, India and China first. And only when those guys are full, only when they reach current, can we expect to see visa overflow into the EB3 category. There may be a little bit of EB3 movement as they get close to the end of the fiscal year and sort of, confirm and understand, what kind of visas they have left. But, that's my take on it. let's see what else we have here. So from Sneha Mehta again, I think this is sort of a follow-up on the last question. So, hi Sam and Brian. I have a green card and I took a vacation in India for 4 months in October 22. I returned to the USA in May 22. Can I go back to India for 4 or 5 months in 2022? Does it cause any issues? So, Sneha, the devil is in the details. A exit for 6 months at a time is sort of the classic flag. But as I mentioned earlier, a bunch of trips a bunch of trips that could suggest that maybe you don't reside in the United States, you're just coming back to visit the United States, could cause issues. So yeah, does it cause any issues? The answer is I don't have a crystal ball. I can't tell you for sure, but perhaps. I think you would probably be well served by talking to an immigration attorney, once about, how to preserve your permanent residence, especially if it seems like you have long trips of time outside of the United States, because really the devil's in the details. For example, if it's your employer sending you outside the United States on a trip, the factors really vary quite a bit, whether your permanent residence is preserved or not. Let's see here. So from Siva, so have you received approvals for EB2 refiled cases in April 2022? That is the most, it's kind of an anecdotal question. Siva, my honest answer is I don't recall seeing anything filed that recently and that approved that quickly. However, a little bit earlier in this fiscal year, I have seen, cases that have been approved in a matter of months. So I don't think it's crazy that you've heard of, cases being approved in, I guess that would be around 3 months at this point. But I can't say that I've seen that exact scenario play out. So the bottom line is during a AILA USCIS Ombudsman event, USCIS did mention that you could expect cases filed in April 2022, that they thought they could approve those during this fiscal year, which ends on September 30th. So, those of you who refiled EB2 second adjustment of status fairly recently, I don't think it's crazy that you should see green card approvals sooner rather than later. Let me see here. I'm going to keep on going with these questions, and I think we have a good set of them, so I thank you guys for them. For those of you who like what we do and like us, always appreciate the thumbs up and likes and subscribed. I get a little notification on my phone every time somebody gives us one of those, and it's fun to see. So this question is from Ajay Shah. My priority date is in July of 2012. I have raised service request, Congress request. My AOS is still stuck in the TSC. Is there anything we can do to trigger the transfer to the NBC? A great question. My honest answer is likely not. USCIS moves their cases. They move their workloads as they see fit. And one of the first things I learned as an immigration attorney is you file your case where USCIS tells you, and they're going to deal with it as they please. It's kind of upsetting that your priority date's that old, Ajay, and that your case hasn't been moved to the TSC. Outside of the Texas Service Center. However, I think back to the USCIS FAQs and the policy statements they've made of late. It's not necessarily a problem that your case at the TSC, the Texas Service Center. Your case may not be stuck. Why do I say that? Because when USCIS earlier this year explained their transfer of cases out of the Texas and Nebraska Service Center to the NBC, they explained that some cases would be left at the Texas Service Center because there are officers in those service centers actively working on them. So one thing you may have, I don't see on your list here, Ajay, is you could consider contacting the USCIS Ombudsman. The USCIS Ombudsman is an office within USCIS that basically checks on the rest of the agency to make sure that they're doing their job. I would say that I know that the Ombudsman's Office is backed up with requests, but it is something you might consider doing. So big picture for you, Ajay. This Texas Service Center is not necessarily problematic. I really don't think there's much you can do to tell USCIS what to do, because who are we to think we can move the US government? But consider an ombudsman request and keep pressure on them. I don't know what kind of responses you received on your service requests or the congressional requests, but the big picture, Ajay, is USCIS is talking like they're going to approve cases during the fiscal year, and your priority date is very old. It is very current. I think I would still hold out hope that you can see an approval before the end of this fiscal year, which ends on September 30th. Which, if USCIS meets their obligation, that's going to be a good time for a lot of people. There's just going to be tons of green cards issued, and well, I'm probably going to be a busy guy in August, September, going to a lot of green card interviews, which will be very fun as well. So, going to keep it going from Binyam. So, a very simple, straightforward question. So, why do NBC transfer cases go to remote field offices? Why can't the NBC adjudicate it? To sort of explain this for everybody else, USCIS since early this year has been transferring cases from Texas and Nebraska to the National Benefits Center. However, they've explained these cases aren't really being adjudicated at the National Benefits Center. They're going out to local field offices all around the country. And historically, traditionally, the reason why a case would be sent out to a local field office is because they want to bring somebody in for an interview. When they want to interview somebody as part of the green card process, they will send, you to the local field office and bring you in and talk to an officer. But the bottom line for me, Binyam, is that, USCIS, they do operate in a logical way most of the time, and my best guess is that's where they believe the manpower is. If they have people staffed in their local field offices who are not busy and are capable of adjudicating employment-based adjustment statuses, why not send them there? If the NBC does not have staff to do it, give them to local field offices. Bottom line is I believe that they're putting cases where they believe they have people to adjudicate them. So, and sort of the execs, same kind of questions from Rahul Jain. It's, do cases that move from the NBC to field office, or do they get adjudicated directly at the NBC? And the answer to that question is that it really does seem that they are getting sent out to local field offices. To give you guys an insight, when I talk to clients and when we get adjustment of status RFEs, as we're getting a fair amount of them lately, we take note of where they come from, right? And really, they are not coming from the places I would expect. We're seeing, people in New York getting RFEs from Florida field offices, North Carolina field offices, field offices that don't, field offices that you wouldn't expect, to have your case are getting it. So again, I genuinely believe that's where USCIS believes their manpower is, and that's that. So got a couple questions here, and I thank you guys for giving to me. I always appreciate anybody who's willing to tune in. So from MP, my LIN, that's Nebraska Service Center, EB3 application transferred to the National Benefits Center. However, there is no update on I-45J, EB3 to EB2. Can I get the green card before September 30th? So it sounds like you would have submitted an interfiling request, MP, when you're talking about an I-45J from EB3 to EB2. So my first thing to say is not getting updates on interfiling is very common. USCIS, interfiling, they don't issue a receipt notice, generally speaking. They can eventually issue a receipt notice on the I-45 Supplement J that you send with your interfiling, but don't expect them quickly. Bottom line is, can I get a green card before September 30th? USCIS is talking a big game. They're quote unquote well positioned to issue those green cards. So yes, it is possible, but really in these last 4 months of the fiscal year, USCIS has to approve 130,000 green cards. I am employment-based green cards in order to make sure they don't waste any. I am rooting for them. I know they don't want to waste them because they will get railed in the press, and their director will probably get reamed by Congress if they waste a large amount of them. But it just seems like an incredibly difficult goal to meet. 130,000 green cards, almost an entire year's worth of green cards, the normal allocation of 140,000 in just 4 months. I am optimistic it seems possible, but again, what I say is don't believe it until the card's in your hands. Don't count on it until it's there. A couple more to go as we get to the end of the hour. EB2, January 5th, 2015, from JCP Ready. Any thoughts on being current in October? I would say, I feel for you, JCP Ready. You know, the dates for the final action dates right now for EB2 are 1st of December 2014. You're a month off, a month and a couple days. I don't make a career out of betting on the Visa Bulletin, because the Visa Bulletin always surprises us. But you know, if anybody was likely to be current in October of 2022, I would say you're up there. You know, you are just so close to the not only the final action date of 1st of December 2014. The dates for filing for EB2 in August right now are January 1st, 2015. Now, there's no guarantee that USCIS, I mean, the bottom line is you're very close. Movement comes in October. I think there's a very good chance, you know, your date can become current in October of 2022. Couple more. My EB2 is approved and received green card. Do I have to withdraw my pending EB3 I-45 as it still shows open and pending? My honest answer is no. USCIS expect talk to your attorney about it. But I would expect that USCIS will close those cases out administratively themselves, because we've seen it happen. Basically, they'll say, hey, you got a green card already, we're going to close out this case. It's coming up on the end of the hour. I seem to have one last question, and it's appropriate because I think I have time for one last question. So from Pradeep Koganti, priority date October 2014, refiled EB2 in May. EB3 as well moved to the NBC, and no action since then. Can we interfile as well to ensure green card approval before 9/30? Any risks with this approach? So, a great question, and I will first be the first to admit that, you know, figuring out exactly how USCIS works and what will work and what will get your case approved is somebody that I don't think anybody has a 100% clear answer on, you know? But there's sort of, I will entertain both schools of thought. You know, from what I'm seeing from you, Pradeep, you know, your EB2, you have a second filing, your priority date is current, and, you know, based upon that filing date in May, I think there's a reasonable chance they could approve your EB2 case in this fiscal year, you know, that clean, fresh, new filing. You know, there's a question of, can we interfile to ensure green card before 9/30? Any risk with this approach? Well, you know, having thought about more about your question, that EB3 case for you, Pradeep, doesn't really seem to be doing anything for you right now, because your priority date of 10/2014 is nowhere near current in EB3. Arguably, you could move that EB3 case to EB2, and maybe, you know, the logic is that case is older. That's a case they might be able to approve faster than the new one. However, well, that's it. You know, the risk is, you know, I guess the risk, Pradeep, is you're leaving behind the EB3 category. You know, even though I don't think it seems likely that EB3 will move any great leaps forward to make your priority current in the EB3 category, you know, you're leaving a category behind. You know, that's what you're losing. So, you know, it looks like I'm taking one last question here in the hour. USCIS reported around 150,000 green cards approved until the end of May 2022. That's what they're saying on FAQ, which they seem to be updating on a frequent basis. And, you know, that means that there are about 130,000 green cards left to approve. And the last months of the fiscal year being June, July, August, September. A great challenge for the agency. I don't think that they are in an enviable position doing essentially a year's worth of work in 4 months. My sincere hope is that they have done the background work such that they're going to just be bam, 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 approving all those cases in the last 4 months of the fiscal year, but that remains to be seen. So on a related note, I think our topic for next week is going to be, visa bulletin predictions and what kind of rollover they're going to be, and that's going to affect really how these dates move forward and how many people get to file green cards next year. I'm Brian Burke from Sam Shehab and Associates. Thank you, all of you, so much. I will see you guys next week. Bye-bye now.